Okay, so lecture 14, we're going to look at the last lecture here on mortgages, considering the borrower's rights in signing the mortgage and in the mortgage agreement, and also any defences that may be available to them in holding off a repossession or sale. So that's not where the borrower is trying to control a sale or to fight repossession, but also looking at the defence of undue influence. So what I'd like to do in this session is consider the few mortgagors, the borrower's rights and protections that are available to them. So I won't go into that in a lot of depth because ultimately it's not incredibly important in some of the scenarios you'll be facing in the seminars, and therefore obviously that mirrors into assessment too, but it is an area that is important to know the existence of. So the main ones then being equity of redemption, and we can look at that in contrast with the ability then for the bank to behave in certain ways. So we'll see that when we look at the borrower's rights and protections, they are very outranked in contrast with the banks. And really, we've looked at the borrower's ability to respond where the bank are using their rights. So we've looked at the borrower's ability to respond where there's been a repossession or a sale, and those would be considered rights as well. So we've looked at those rights as we've gone through an action coming from the bank. Here we're just looking at the rights that exist in isolation of that, just the ability to have rights under the mortgage itself. We'll then consider the defence of undue influence and what undue influence means, how to establish it as a defence, knowing that any defence has policy considerations too, and then procedures to be met. And the idea that what that does is that would create a defence that evades action from the mortgagee to seize the house and or sell it, because it acts as a defence mechanism to that action. That's effectively what's happening there. So that's what I'd like to cover in this session, starting out with the three key rights and protections available to the borrower, the mortgagor in this instance. So we've got the right to redeem, equity of redemption, and the fact that there should be no clogs or fetters on the equity of redemption. All of those things in some ways meaning something similar, in that it's allowing for the borrower to have the property back at the end of the payment. So all three of those things are about the idea of redemption. Not saving our soul, but redeeming the property free of the bank's interest on payment of the debt. So the right to redeem really is that right to pay off the debt and take the property back free of the bank's interest. The equity of redemption being the borrower's equitable right to redeem it as a property, and the right to have any equity that comes from the sale of the property were anything to go wrong. So if there is a sale of the property, that money can go to the borrower as well as potentially satisfying the bank's debt. So that happens where there would be a property sale that the borrower chooses to make. So if they sell their property and they make money from it, they can satisfy the bank's debt and then take the profit themselves. So that's the equity of redemption. Also considering the fact that there should be no clogs or fetters on the ability to behave that way, so that there shouldn't be any unfair restrictions put in by the bank that would prevent the borrower from behaving that way. So the lender can't hinder or prevent the borrower from being able to redeem, from being able to have the property back on payment, and or to have any monies that have accrued as profit once that debt is satisfied. So we've thought about that previously when we've considered the fact that there's an artificial contract date put in, because that indicates the ability for the borrower to pay off the debt and take back free of the bank at that moment. So in the eyes of the law, the parties would agree a date when the mortgage will be paid back, and that becomes the contract date. The mortgagor or the borrower has to pay back by that date. Equity would therefore allow for future payments to be made after the contract date has passed, because that would allow time to pay it off. Effectively, what those two kind of conflicts mean for us is that fictitious date that I talked about previously. What happens then is that they put in a short-term date of 6 weeks to 3 months after the contract being signed, to allow that date to that contract date to have passed, so that after that moment the borrower could technically be able to satisfy the debt, pay the bank back, and redeem the property. So that's why that short-term date has been put in. The equitable element of it allowing the borrower to carry on paying the debt off after the passing of the date, but the existence of that date meaning that it exists as a legal redemption date that they can call upon if they fell into some money and were able to satisfy the bank's debt. Obviously, then as well, it acts in the mortgagor's interest, the mortgagee's interest, because it allows either party to satisfy their rights in an early way. So it allows for the mortgagor to pay back early, but it also allows for the lenders to have their remedy. So the mortgagee can have their remedy after the contract date has passed. And we've looked at that arising and exercisable moment as a point of sale as to whenever the bank could behave in that way. So that's the right to redeem. What then happens is that creates a bundle of rights for the borrower, inclusive of that right to redeem, and as well as that, the right to let the property out in order to satisfy funds if they're allowed to do so, obviously under the terms of the contract, and the right to sue. So what this bundle of rights is an interest in the land for the borrower. The bank have to behave in an equitable way that accords with the borrower's right to redeem, and therefore this contractual arrangement allows for cesse on redemption, which we've talked about before. The bank's interest stops whenever the property monies have been paid and the property itself returns back to the borrower. So equity of redemption and the right to redeem are very closely mirrored. It's a bundle of equitable rights for the borrower that allow them to behave in this way. Understanding then that the bank have to behave in a way that doesn't prevent that from happening. The bank have to be seen to behave in a way that is fair and allows for redemption to occur. So a mortgage is a form of security, and the mortgagee should free the property at the end of the term and not use the mortgage as a device to obtain some form of control over the property. Clogs or fetters would be a hindrance or a prevention of the borrower being able to redeem the property, and that cannot be so. So we see these kind of broken down as ways that the bank shouldn't behave in overly restricting, clogging or fettering the borrower. The right to redeem itself must not be an illusion, so it can't just be a notion that the borrower will end up back with the property at some stage. It has to be fair. So in Fairclough we could see that the leased property that was subject to the mortgage had no ability to redeem till 6 weeks before the end of a 17.5-year lease term, effectively making it worthless. So the quote in that case saying, "Is there any difference between forbidding redemption and permitting it if the permission be a mere pretence?" So this idea that if you aren't able to redeem it until a few weeks before the end of the term, that wouldn't make any sense. So that's why that early contract date benefits both parties. There can be no unconscionable or oppressive bargains in how the bank behave as regards the mortgage terms or the mortgage agreements. In multi-service, we could see a hard bargain was enforceable where the borrower and lender were deemed to be equal, and not an experienced mortgagee taking advantage of an inexperienced borrower. So in multi-service, we can see that there wasn't deemed to be any wrongdoing, because in that case we had two business people with independent advice from solicitors. However, courts don't look to reasonable, they look at whether there's oppressive conduct, bearing in mind the influence on the idea of freedom of contract and how equal the parties are. So they will look at, it will be a bit more subjective in terms of looking at the positions of the parties and seeing if there's something oppressive being done as regards the terms of the mortgage, perhaps the interest rates, the term itself, how long it's for, etc. So if that is seen to be unconscionable or oppressive, the mortgage itself could be overturned. The mortgagee should not obtain collateral advantages. So that's where the borrower would be gaining something else in addition to just the repayment of the debt and the interest payments. That if there's some sort of additional tie or bind between the parties, that's not really what a mortgage is about. It's not a way to obtain loyalty or to further other business contracts. It's about land law, so it's not, shouldn't be used in that way. In Noakes, the borrower had to undertake to purchase alcohol solely from the lender who was their brewery, but any such agreement should not be made to continue after mortgage payment, as you should be able to get the property back in a free condition. So it's not to say that you can't tie a mortgage into an agreement completely, but that obviously that whenever you're able to free yourself of that relationship, it doesn't continue in any other way. So if you have to take the beer from the brewery and they've lent you the money to buy the pub, then once you free yourself, you redeem, you free yourself of the brewery's interest in the land, meaning you've repaid them the debt. You don't then have to carry on taking their beer. So it's a collateral advantage can technically exist during the period of the mortgage, but it's not something that should be tied ideally into a mortgage, and definitely should terminate on repayment of the debt. Looking then at whether there is an unfair relationship between the debtor and the creditor, we're seeing again that the courts will look into the equality of the bargain and the equality of the parties within that bargain. So the courts will reopen what they refer to as an extortionate credit bargain if it contravenes principles of fair dealing. And the 2006 Act goes further than the 1974 Act, which just related to extortionate credit bargain and contravening principles of fair dealing. The 2006 Act actually looks to the relationship between the debtor and creditor. It looks at any of the terms of the credit agreement. It looks at the way in which the lender has exercised or enforced their rights under the credit agreement. It looks at any other thing done or not done by or on behalf of the lender, either before or after making of the credit agreement or a related agreement. So that basically does drill into that relationship between the debtor and creditor, the lender and the borrower, and see whether there has been fair dealings, or some sort of oppressive term or nature in which it's being exercised. So all of this means that the borrower takes the property back at the end of this fictitious date, which is usually 6 to 3 months, and they have to be allowed to do that. They have to have been treated fairly. the mortgage terms have to be seen to be fair, and if there's inequality in the parties, the courts can drill into that, not just using case law but statutory provisions there now as well. Okay. So technically what shouldn't happen is some form of malpractice or misdealing where mortgages get passed or transferred, or you're kind of locked into situations where you're out of control of your own debt or your relationship with your mortgagee. You shouldn't be in a situation where mortgages are getting transferred across, or that you're not able to get yourself free of the bank if you have the money to repay them. However, obviously we can consider this in perspective when we're relating it to all of the many rights and remedies that are available to the bank in signing a mortgage agreement. So we have the right to possess from dry ink, we have the right to sell from the moment the contract date has passed and the bank want their money back. We have foreclosure not being used anymore but basically being replaced by the right to sell. We have appointment of a receiver for commercial property, and we still have the ability to sue on the debt of payment. So there, you can see there that the compared with basically just the ability to take the property back free of the bank on the payment of the debt, the mortgagee's rights are huge in contrast. And then we can see that the borrower's rights, sometimes the ones that aren't covered in today's lecture, are responsive in nature. So the right to possess for the bank gives the right to the borrower to try and contest or hold off possession. The right to sell can then also lead for the ability for the borrower to request a sale instead. So apart from those kind of reactive rights, the only true right available to the borrower is this notion of equity of redemption and the ability to take back the property free of the borrower at the end of the payment of the debt, and not have been oppressive or have some sort of collateral advantage or bizarre terms that would be oppressive in nature written in there. So actually, we can have situations where a repossession or a sale occurs relatively easily. The saving grace, I suppose, in the current economic situation is that banks are just not able to do that as easily anymore, and there are pre-action protocols. There's FSC standards. There are all sorts of ways in which the bank are seen to be having to liaise and accord with the borrower to avoid it escalating to that stage, because effectively it's in everyone's interest to keep the borrower in there paying something and or protecting the asset. Okay, so moving on then to a consideration of undue influence acting as a defense mechanism. So undue influence would occur where a party feel that they have been potentially pressured or some form of coercion is used to secure their consent to a mortgage agreement. What undue influence then does is it creates a defense mechanism. The defense being to the action of a bank. So a bank wanting to repossess and or sell a property would then meet with a mortgagee who's stating that they didn't know what they were signing, or that they were coerced into signing it by somebody manipulative who is also the fee simple absolute in possession holder and a fellow mortgagor. So the 1807, very early definition we have there, relates to a person's intention to enter into the transaction having been procured by unacceptable means. So, starting to think about consent and intention being negated by somebody behaving in an unacceptable way. This is updated nearly 200 years later, and we can see that in 200 years there isn't a massive escalation in how we would articulate or identify the behaviours and what it's done to intention to contract. We've got Ettridge in 2002 stating that the means used is regarded as an exercise of improper or undue influence, so those unacceptable means, I'd imagine, and hence, there we go, unacceptable. The consent thus procured ought not fairly to be treated as the expression of a person's free will. Exactly that, what was stated previously. That their intention to enter into the transaction is effectively nullified. They aren't intending to contract with full information and freedom of will because they're being pressured or coerced through unacceptable means. So we can see in 200 years we don't move very far forward in thinking about a new definition for undue influence. But as a defence mechanism, the same as any defence, so you'll have looked at criminal defences, you'll have looked at defences in contract, etc. With any defence, there are procedural criteria that we would be looking for, and there are also policy factors to consider when utilising a defence. You'll be very familiar with floodgates, and especially in criminal cases where you're thinking about things like insanity or self-defence or provocation. To allow those things to be used freely and without making it very tight and very procedural thing to meet, you would create a scenario where lots of people would know how to play the game, and you'd have a criminal behaviour being excused for very little evidence of meeting the criteria for that defence. So not just the criteria to meet a defence, but the fact that those criteria are evolving with a policy consideration behind them. They're thinking about what the impact would be on society as a whole in using this defence. Because obviously, if we just allow people to say we didn't know what we were signing or we were pressured into it, then mortgage agreements up and down the land would be voided. Hopefully you can remember from contract law that that's no excuse and no defence. You can't just say in contract law that you didn't know what you were signing and therefore you shouldn't be bound by your contract. You're seen to have, as an adult with capacity, been responsible for signing that contract and therefore being bound by it. So it's an unusual defence, and I'll look into with you how it's kind of come about. But Nicola Jackson, in her Gateway to Landlord book, gives us a very good example. It unfortunately is usually a wife who's been deceived in these scenarios. We see husband and wife owning a home as joint freeholders, so both on the fee simple, absolute and possession legal title. The husband wanted to borrow heavily from the bank in order to fund a business expansion and will have to mortgage the house. So taking money from the house in order to put it into the business, giving the bank a hold over the property, a percentage of their home in return for money. So not a first mortgage, not a mortgage to buy the house itself, but a mortgage in need of money. So the husband has told the wife that this was the only way to save the business, which might not be true, and that if she did not sign the mortgage, he may go bankrupt again, which may not be true. The wife has no understanding of these issues, has left financial matters to the husband, and goes along with the application, signing it. If the business then does fail, and they're not able to keep up with the repayments, the bank will seek repossession. So then we're thinking about a defense mechanism as regards that repossession. And what will happen is that undue influence would kick in to establish that she's a victim and that the mortgage cannot be enforced by a lender against a victim, because in this case the signature has been procured unfairly. She hasn't consented with her own free will. Her husband had some form of ascendancy, so it was higher than her, or more important than her in financial matters. It doesn't completely disable any right of the bank. They will still have the husband's equitable interest and can apply to the court for a further clarification, really. But in determining as a defence mechanism as to whether there's been undue influence, that would restrict the lender's action against the victim in this scenario. So if you think about that from a policy perspective, you're referring to this woman as a victim, and therefore the law is trying to protect her against a wrongdoer, her husband. But the bank aren't always perceived as being a wrongdoer in that situation. The bank have lent money in return for a percentage of a house, and they aren't getting their money back. So effectively you could see this as two victims: the victim of the bank, who have given money and aren't getting it back, versus the victim of a wife who's been deceived by a husband and is effectively being kicked out of her home. So the law has to kind of decide which victim it's going to protect in this scenario. And what I suppose it's aiming to do is pass or transfer some of the blame to the bank in creating some protective mechanism for people like her. So they're pushing the burden back to the bank to say that it's their responsibility to make sure she's not a victim. And that's where we're headed now. So yes, there is a need to protect innocent parties where their will and choice has been removed. They've been manipulated into something and it could cost them their home. But against that, contrasted with that, we see law always trying to balance out parties' interests. We also have the need for lenders to be able to get their money back and have their investment returned, as otherwise they aren't going to lend as often, and that will impact on the economy and people's ability to buy houses, which there already is an impact on anyway. So in Ettridge, they were very aware of that and felt a need to strike the right balance. And that's the most current and relevant, up-to-date case on that. And that's where we'll be headed in a moment. A lot of the criteria or characteristics that we're going to talk about came from a case of O'Brien's. So we can see Barclays Bank and O'Brien as the instigator for this conversation in creating some procedural knowledge and articulating that it's the bank's responsibility really to protect her. Here we have a husband creating again a second mortgage on the family home as security for the company overdraft, so taking money from a bank and putting it into his business in return for a percentage of the family home. He had lied to the wife about how much money it was going to be and how long he would need it for. He said to her that it was going to be £60,000 and he would have it back to the bank within 3 weeks. The wife then, because she isn't really involved with the financial affairs, signed those documents without reading them, and no one from the bank explained them to her. The overdraft itself and the loan therein reached £135,000. It was built into the term of their mortgage, and the bank sought repossession. And O'Brien, in determining where the balance would lie between a bank who are a victim of somebody who's not paying them back and a wife who's a victim of a duplicitous husband, the court felt that the bank were at fault because yes, we have a duplicitous husband who's misled his wife, but the bank knew about her, and therefore that created a notice of her interest in the property, and that meant that they were duty bound as the more reliable and authoritative person in this whole relationship to have explained it more clearly to her. So putting the onus back on the bank, really, to have a view towards somebody like that and have their interest at heart. Which again, you have to question, is it a bank's place to protect a vulnerable wife from the deceit of her husband? It's quite an odd one to think about. So in Ettridge we have that. In Ettridge we have it clarified for us, brought up to date, because we had other case law where we were thinking about classification. Was there such a thing as actual undue influence that we could find as a question of fact between one party or another, or was there a presumption that there was going to be undue influence because of a relationship of hierarchy? One party was more high up or had ascendancy over the financial transactions than the other. So in Ettridge, the wife again had not fully understood any advice or any information that she signed. The husband's business had gone broke and the house was again being repossessed. Ascendancy was there within that relationship because she left the financial matters to the husband, and again he had taken advantage of her in order to obtain consent. In that way, her proof that her free will had been overcome meant that her signing the mortgage was not her true will and consent, and the burden rests therefore on the bank to show that they have clean hands, I guess, in that case. So Ettridge evidence that it arises out of a relationship between two parties where one has acquired over the other some influence or ascendancy, so a hierarchy where one is higher than the other, over which the ascendant person takes unfair advantage of the other. So it's not a natural situation in every case. So we do have presumption where you would have a hierarchy. You would have parent to child, solicitor to client, trustee to beneficiary, but not in situations where you've got husband and wife and partner. What the courts have to do then is look more closely at that relationship. So they have to look for these two things. They have to look that there's trust and confidence placed in the party, the wrongdoer, in relation to the management of the financial affairs. So the wrongdoer has to be kind of in control of the victim in some way by taking account and taking control of the financial affairs. And the transaction itself, the agreement or the thing that's being signed for, is unusual or is a large sum. And we'll look at those together. So we can see trust and confidence in ascendancy naturally in certain relationships, like teacher-student, like parent-child. But in Stringer, it was actually reversed. Here we had an elderly mother who had potentially been taken advantage by her child, grown-up child, because she could show that she had put trust and confidence in her son, because she had little English. English wasn't her first language, and she didn't understand the complexities of the financial agreements and transactions that she was signing. She had relied upon her son for translation and for support. So there was ascendancy there between the son as the kind of wrongdoer and the parent as the victim in that case. So a reverse of how we would usually see it. In Thompson, however, we do have a mother transferring the house to her daughter on repeated promises that her daughter would make the payments. Here the court said there was no undue influence in that situation, as the mother had been aware of the risk of the transfer. So we have two parent-child situations there, one where there was undue influence and one where there wasn't, because in Thompson and Foy, the mother was seen as being aware enough to know what she was doing. So the courts will look at the relationship between the parties and see whether there's some form of ascendancy, trust and confidence placed in regards to the financial affairs being handled by one more than the other. As well as that, the transaction itself should be unusual or require some form of what they refer to in the Barclays case as a manifest disadvantage. Something in Ettridge that they refer to as not readily explicable by the relationship of the parties. So there was an argument by the husband that this was just a nice thing for his wife to have done for him. And that's not normal. That's not kind of a normal kind thing to do for somebody, to give them half of your house. It's normal to give them a watch or a nice set of golf clubs or something for him, but not half of her house to sign away to him. So it wasn't her just being a nice wife and giving something lovely for Christmas. This was her signing away her rights in her home over to the bank to help his business. So that transaction is unusual and needs to be explained more clearly than just doing something nice as an act of generosity. In Stringer, there was a request to put the house in jeopardy in order to finance the unknown business of someone's son. And again, not just the normal thing that you would do for a child to give them a nice gift. You are again putting your home in jeopardy in order to finance their business. So that's not a normal thing to do. So we can see that Stringer case again crop up where the son has said, oh no, my mum just did something nice for me. Well, that's not just something nice, that's her putting her home at risk. However, in Turkey, we can see that the agreement for a couple to transfer the house to the father in return for payment of the mortgage monies was an ordinary transaction. There was no gift there. They were going to give the house to the father in return for payment of the monies. So there wasn't anything bizarre in terms of a gift in that situation. So you're looking at from two situations within an undue influence case. You're looking at whether there's been trust and confidence placed in one party as regards the financial affairs, and then that the transaction that they've signed, the agreement that's been signed, goes beyond the pale of just doing something nice for your partner or for your child. What that can do then as a defence is to set the mortgage aside altogether as regards the victim. So the victim will be allowed to have their share of the mortgage set aside as a defence mechanism. So the mortgagee therefore has to make sure that they are going to protect themselves from such a thing happening. And the one way they can do that is that they have constructive notice of the other person where there's two signatures. And that's what that surety means in the brackets. Where they see two people needing to sign a mortgage or more than one party, they are therefore put on what's called inquiry, where it wouldn't financially advantage them and there's a risk that the debtor has committed a legal or an equitable wrong. So what they will do now is they won't, the bank aren't going to sit down with these parties and ask whether potentially someone's husband or wife have lied to them and put pressure on them to sign. All that this means is that the bank, where they see more than one signature on a mortgage, will have a procedure to follow. And that is known as inquiry. The bank will be put on inquiry where they see more than one person on a mortgage agreement. And these are the steps of inquiry. So these are set out in Ettridge as the things that a bank have to do. So the bank will contact the second signatory, the surety, to nominate their own solicitor, an independent solicitor. So the wife will be contacted in Ettridge to nominate a solicitor. The wife then replies to the bank with the name of their solicitor. The lender discloses all the relevant details of how much it is, how long it's for, what the repayment schedule is, all of those details to her solicitor. The solicitor will then invite her into a meeting without the other party, the debtor, the wrongdoer technically, potentially. Explain all this to her, and then if she wants to go ahead, the solicitor will write to the lender explaining that all of that information has been covered with her and that she's still happy to sign. So, effectively, since Ettridge, what has now happened is that banks up and down the land, every time they see two signatures on a mortgage agreement or know that they're looking for two signatures on a mortgage agreement, will behave this way. They will write to whoever the other party is and tell them to get a solicitor and have to have evidence that this has been conducted. It's fine for the banks. Is a procedure to follow. It's great for solicitors. It gives them some income and some stuff to do. If we're thinking about a victim and helping or protecting the Mrs. Ettridges and the Mrs. O'Briens of this world, I don't think it's a great thing. Yes, she's going to go into a meeting and be told that her husband has lied to her, but if she's that financially insignificant in relation to ascendancy, if she's that vulnerable that she has allowed someone else to take control of her finances, and now she's in a meeting where she finds out she's been lied to, potentially being driven there by the man who's done that and getting back in the car or getting back in a bed with him later, I'm not sure that she's protected. I'm not sure that her signature to say that she's okay with that goes far enough to protect her. If that's what undue influence is meant to do, it's not doing it by this procedure. What it is doing is it's absolving the bank of responsibility by giving them a process. What it's not doing is actually protecting a vulnerable person who could still sign an agreement that they don't want to sign because they're about to get back in a car with a man who they know has lied to them. So it's an interesting point. If you look at it as a contract lawyer, you would go, well, you don't sign a contract that you don't want to sign anyway, and if you do, you're bound by it. It's not as much as duress, it is undue influence, but you can't argue undue influence anymore if the bank have followed this procedure. So it's worth a thought if you wanted to do something regards the bank and the borrower. It's an interesting area, is my perspective anyway. So thank you very much. What I wanted to do was look at the borrower's rights and protections as a standalone thing, basically them just revolving around this ability to take the property back free of the bank at the end of the payment of the debt. When you contrast that with how the bank can behave and what's available to them, it's actually quite scant. We looked at the defence of undue influence, so the ability to hold back the bank if we can find that there's been some wrongdoing and coercion into signing a mortgage agreement that you didn't want to because you've been lied to. We've looked at the fact that you can establish that if you've been in a relationship where somebody else has ascendancy over you and you've signed something that should have been explained to you. That would act as a defence to allow you to hold off a mortgagee. But that then, unfortunately, since Ettridge, the procedural requirements have evidenced that all a bank has to do is ensure that you go in a room with a solicitor and find this stuff out and then make a decision as to whether you sign the document or not. Thank you very much.